I rarely see applications that are low risk unless they're made up or they are at the very forefront of this industry. They are at the very first one to apply. You're really not going to see that low risk. Most applications have some risk involved. And when I say a mark is high risk, then yes, that is something like if I'm saying it's high risk and it's not going to get approved, I know it's not going to get approved.
Hey friend, and welcome to the Feel Good Social Podcast. I'm your host, Kinsey, and I'm here to help you market your business in a genuine way that works without wasting your precious time. On this show, we chat about social media strategy and mindset tips with a focus on, you guessed it, feeling good. So sit back, relax, and enjoy some genuine conversation for the good of your biz. Hey, my Feel Good friend, and welcome to the Feel Good Social Podcast. I'm your host, Kinsey, and I am just so stoked to share today's special guest with you because her name is Taylor Williams, and she is a trademark lawyer out of Denver who I have actually had the pleasure of working with. So today I am asking all those dumb questions like, how do you know if you need to trademark? How do you know if your business name is viable for a trademark? The steps to getting started in the trademarking process and all that jazz. And you also hear a little bit behind the scenes of my journey working with Taylor to try to trademark the name Authentic AI, which is our sister brand and our sister podcast for Feel Good Social. So we are currently in this process myself with this trademark thing. And it's something that is super, super interesting and eye-opening. As I've been chatting with Taylor, as I've been working with Taylor, there's just a bunch of things that I did not know myself. And so I can't wait to share this with you. This is definitely a must listen if you are a business owner and are thinking about protecting your business name. For sure, she just dishes up all of the straightforward, actionable tips for us for getting started in this process, right? So if you do enjoy this conversation with Taylor, definitely share this with a business buddy who could also use to listen to it and or share it to your Instagram stories and make sure you tag me so that I can see it. I'm at Feel Good Social. And when you tag me, I'll be able to reshare it to my stories, plus just spread you some love in the DMs because I can't wait to connect with you. Okay, without further ado, let's go ahead and dive right in. Hi, Taylor. Thank you so much for coming on the Feel Good Social Podcast, lady. I'm so excited to bring you on the show.
Hi, thank you. I'm so excited to be here and to talk all things trademarks with you.
Yes, this is going to be a super interesting conversation, a super fun conversation, I think, but definitely going to be asking the dumb questions when it comes to trademark stuff. But before we dive into that, I always like to ask a little bit about how you got started doing what you do. What did that journey look like for you?
Yeah, so I started my professional career in a commercial and corporate litigation firm, which is entirely different from what I do now. Litigation is lawsuits. So we were bringing lawsuits on behalf of our clients for a range of different issues, and they were complex and the cases took years to resolve. And it was just very high stress, high value cases, and nobody was really happy. And I knew going into this type of practice that I wasn't going to enjoy it. And I had tried to bring trademarks into that firm and they didn't really care to have that even there. So I had voiced to them that I wanted to start my own practice. Again, I was still working at this large firm and doing trademarks very minimally on my own on the side. And then over time, I was just like, I love working with trademarks. I love helping clients secure their brands. It feels good. It's exciting. And when I really started sitting with that and thinking about that more and more, I was like, I have to get out of this law firm and create this practice that I know is possible and that I now have. So over the course, it was not a quick transition. It did take a few years to really plan and execute and then to make that decision. But it was very much night and day, litigation straight to trademarks.
Oh my goodness. I love that so much. And thinking about your journey and like the different types of a lawyer that you can be and all the
Yes.
different types of things, the cases you could work on and all that stuff. And so it's good to hear that you're doing something that's a little bit more enjoyable than the litigation thing now.
Yes.
But did anything kind of start your interest with trademarks specifically? Like, why did you kind of know that that's where you wanted, the avenue you wanted to head down, I guess?
Yeah. So when I was in law school, I saw a job posting for a trademark clerk. It was this solo attorney. She just wanted someone to be a law clerk for a very limited amount of time. And I was like, okay, I can do this. I worked full time during law school, and I also wanted to work a little bit more. I had 2 jobs at one point. And so I signed up for it and I did it. And she was like, do you have any experience with trademarks? And it's like, no, but I have signed up for the trademark course at the law school for the next semester. So I will be learning it alongside working with you. And she was like, okay, then let's do this. Again, it was only a few hours a week, so it wasn't really crazy. But as I started working for her, I realized that I really loved the practice. And ever since that time in law school, I'm like, I cannot like get this off of my mind, off of my heart. And I just knew I loved it from that moment forward.
Yeah, totally. And then just like kind of turning it into your own firm and everything like that. Like, were there any kind of like, I don't know, nerve-wracking moments for you or like hurdles that you hit along the way?
Yeah, I never wanted to start my own law firm. I never wanted to have my own practice. Like when I first started as an attorney, I was like, I don't want to do that. That felt crazy. I wanted to work for another firm, but this solo attorney could, because she was solo and didn't have the capacity to hire me as an associate attorney following law school, she just couldn't take me on. So that's why I went to the litigation firm. But, I was like, okay, I can at least try to work for you and try to bring in business. And even then she was like, I don't know that I will be able to pay you doing that. Like, it's just not very possible. So that was scary. And then when I started thinking, okay, I'm going to do my own practice, then thinking, okay, this other attorney says, who's been in practice for years says that she can't pay me. And now I'm starting from scratch. Will I be able to make this a thing and be able to even pay myself? And so that was very nerve-wracking. And then just trying to find clients that I felt like were the people for me and not just taking on clients to take on clients was something that was also scary. And when I first started, just that expectation, and I've always, done everything possible for my clients just to make them have a great experience and try to go above and beyond for them. But when I had these first clients, it was like, am I doing this right? Like, obviously the work is there, but like, are they having a good experience? Am I making them happy? And so it was just a lot of different moving parts that were very much scary when I started.
Yeah, definitely. And you guys, Taylor and I are actually working together. We have worked together, I guess. She's helped me put in an application for a trademark for authentic AI, which I'm so excited about. So we can definitely reference that throughout our conversation at KB and stuff. But I can definitely attest that your process is fairly seamless and just to make it as easy as possible, which was so nice because during our discovery call, I was talking with her and I was like, girl, I don't know anything about this stuff, but I feel like it's something I should be doing. So maybe we could go to that direction now. Like for someone who's like, okay, like trademarks, they've started a business. They're like, this feels like something that I should be doing, but like, I don't really know why or how to go about it or anything like that. Like, let's kind of go down that path. I guess, why should we trademark our business names to start out with?
Yeah. So a lot of people don't think about trademarks until they're further along in their business. And that is because you don't have to register your trademarks. And most business owners think, okay, I have the LLC name. Like I own this LLC name. I've registered it with the state. So I have this, I have the social media, I have the domain. So I don't really need to do anything else. You've already done so many things with your name that you think, okay, this is protected. But it is not. Trademarks are protecting your They're called source identifiers. So your business name, your product names, your service names, courses, things like that. So trademarks are going to protect those things nationwide. And that is just huge in today's age where most business owners, especially business owners that I'm working with, have an online presence. Whether they're selling their goods online, they're offering their services online, they're putting themselves out to the entire nation, if not, other countries. So when they don't have that trademark, if you're in California, for example, somebody in New York can pop up under the same name. And if you don't own that trademark, there is nothing you can do about it. So I always recommend business owners think about trademarks at the very forefront of anything they're doing, whether it's naming their business, creating a program, whatever it is, you should be considering whether you love this name and if you want to use it long term, and if you would be upset if somebody in another state did pop up under that same name. So if they do pop up and you see, okay, they're using my name and you have that federal trademark, you can then send a cease and desist and have them rebrand entirely. And of course, as a business owner, you don't want to be on the flip side of that where you have created your program and you are launching it and then you find out somebody is suing you because they actually have the federal trademark registration. So there's two sides of that coin. You're protecting yourself from your name getting stolen, and then you're also protecting yourself from getting sued by another company. And most people think like, I'm just a small business. I'm a small business owner. Nobody cares if I use this name, but that is very much not the case. And companies, large and small, will go after any size company to protect their trademarks. They have to do it, and you should too if you own a trademarks. But having that trademark is just going to give you that ultimate protection, like I said, nationwide. So it's so important to consider at the very beginning of your business and as your business evolves, as you create new products forever. So it's a very much an ongoing thing. It will never stop. You will always have to be considering it.
Totally. I mean, I have seen that happen to multiple businesses who I've known, who I've followed online or even in my local area and stuff. Like say, we have had this business for 5-10 years now, and all of a sudden they're having to completely rebrand and change their business name because of a trademark issue and stuff. So it's so much better, I think, to be on the other side of the coin than that side of the coin. What are some other benefits of getting a trademark? So I know we chatted about that during our discovery call as well.
Yeah. So of course, the nationwide protection is huge, but then when you own your trademark, it is a business asset. So there is value to that trademark. So if you're going to sell your business, sell that trademark, you're going to be compensated for that. If you own this trademark and somebody else wants to use your trademark or a similar trademark, you can then license it out and again, continue to make money off of this word or words that you own. So you have a lot of ability to leverage and have this passive income from these trademarks. And again, the nationwide protection, in my opinion, is the biggest one.
Yeah, definitely. Can we talk a little bit about kind of different names or how to know if you have something that even can be trademarked or if it's good enough or all that different stuff?
Yeah. So there are a lot of things to consider when you are at that point of whether or not this is trademarkable. And I tell all of my clients to consider whether this is something that they love and they're going to use long term. So those are just two general considerations to take into account, because the trademark application process is 12 to 18 months. So it's a very long process, and you don't want to make that investment and then a year from now not be using the trademark. It's not going to be worth it. So consider that. And then just from the legal standpoint, you can't just trademark anything you want. There are, of course, rules to what you can and cannot trademark. And if you have what's called a descriptive trademark, then it's unlikely that you'll be able to register that mark. So you want to have a unique mark, something that can be protected in that sense, so you're not denied by the USPTO. A descriptive mark would be something like computer repair shop or beautiful nails for a nail salon. It's just you're describing exactly what you do, and you're using language that other service providers or goods manufacturers are going to need to use in everyday language to describe their goods or services. So you're not going to be able to claim that exclusive ownership of those words. So it does need to be unique. And then, of course, it has to be something that is not similar to something that is already registered or pending registration. And that is a big one that a lot of people get tripped up on because they think, okay, well, my trademark is different from this other company's trademark. But there is so much case law, and we've seen so many decisions by the Trademark Trial and Appeal Board saying, okay, these are confusingly similar. And just as an attorney, having this knowledge, I know that what you may not think is similar, or people in general may not think is similar, is actually going to cause your trademark application to be denied. So you have to do a very thorough search to make sure that your mark can even be registered because of something else that's existing. And then another consideration is marks that are not registered but are in existence somewhere else, because the trademark registration system is odd in that if you are the first person to file a trademark, file the application for the trademark, and you receive the registration, you have the priority as the first to file. But if you were the first person to use the trademark, then you have rights as that senior user. And so if you are the first to file, but there's a senior user in existence, they can petition to cancel your trademark registration within 5 years of it registering. So you want to make sure that nothing else is out there. And if there is, you are fully aware that this could happen in these initial 5 years. So if they do petition to cancel your trademark, you're not caught off guard and, having to rebrand after investing in the trademark process. So
yeah, 5 years is a good amount of time too, for sure. Yeah. And this is just like kind of a testament as well to why you might want to hire someone who knows what they're talking about when it comes to this stuff, because I know the trademark application process is just kind of confusing in general, but there's all this pre-work that needs to be done. And like you said, it's a 12 to 18-month process. And like, that's just so heartbreaking to have to go through all of that and then have it denied for something that you just didn't know,
Right. And the USPTO, I say this to everyone I talk to, they will take your filing fee. They don't kick the mark back. So if you type in your trademark name in the box in the application, they're not going to say, okay, well, something else is out there. They're not going to give you that rejection until they're going to take your filing fee and process that application for about 10 months. And at that 10-month point, you're going to see an office action that says, actually, your trademark application is denied because there's something else out there. And I have so many people call me and they're like, I thought this registered. I applied for this, over 6 months ago. I thought I had this in the bag, and it's just not the case. So the most important part of the process is all of that research and everything that goes into the application before ever even looking at or filling out that actual application.
And like you said, there's different things that you might not even realize are like, you might just not have the nuance, have the experience, like the history of just following trademark law and seeing what is accepted and what's not accepted, to know that this is a descriptive word versus this isn't necessarily. And then other things too, like you said, when we were chatting about authentic AI versus also possibly going for a feel-good social trademark and whatnot, there are a few things in the works right now. You were saying that feel good social might not be the right time to try to trademark feel good social kind of thing. There's all these different things. I was oh, thank goodness I have Taylor to talk to.
Yeah. And when you search, the USPTO has a search system called TESS. It's the Trademark Electronic Search System. And people will type a trademark into that search system and it will pull up a bunch of trademarks that are registered or pending or marked as dead. And a lot of people say, okay, this application is dead. And so I'm good to use it, or, whatever the case is. But you have to go into these marks and see, okay, why is this dead? Is it dead because another trademark application got it canceled? Is there actually something else out there that didn't show up in test because it's not a direct hit? And so with all of that, then I can see, maybe there is something else out there that is on its way to dying for whatever reason. And then maybe strategically, that's a good time to apply. So yes, a lot of strategy considerations, and it may not be a good time to apply for a particular trademark now, but then down the line, maybe things change or open up, or, maybe it's just something that you decide, okay, I'm not going to trademark this. I'm not going to move forward with this, and move forward with authentic AI in the alternative. A lot of strategy considerations.
Lots of strategy going on into this whole decision for sure. So what are some like common things or reasons that the trademarks are rejected? We might have already covered this, but is there anything else that we need to be thinking about before we're like going into it and stuff?
Yeah, so that is a great question. And the biggest reasons that I see trademark applications get denied, and what happens is if there is something wrong with your trademark or the application itself, the USPTO issues an office action. And I call that office action a soft denial because you have an opportunity to respond. And then if you can overcome those issues, your trademark application will continue in the process. But if not, you'll get a final office action, which is that denial. But the most common things I see in those office actions are those pre-existing registered or pending trademarks, which is huge. Those are the most difficult issues to overcome. The other issues I see are people applying for trademarks for slogans they use on their shirts, for example, because that is not a trademark use. So if the mark is not used as a trademark, it's going to be another big issue and another big and common reason for denial. And then I will also see a lot of issues with the actual identification of goods and services. And that's because, again, when you submit your trademark application, you have to select the classes of goods and services that you're offering. And a lot of people who are applying themselves or using document prep services like LegalZoom or Trademark Engine, they explain what they think their classes are, but they are actually incorrect. And so that incorrect information goes into the application and the examining attorney says, okay, these are not your goods or services. This doesn't match up. And so you cannot get the trademark because this is not what you're doing. And that will cause so many trademark applications to get denied. And it's such a small error and not an easy fix. So that is one of the biggest issues I see. And if that does happen, then you have to apply again. You have to start over at the very beginning, even after fighting to try to see this trademark through. And if you are starting over at the beginning, if somebody has applied for the same or a similar trademark after your first application, but before this new application, you're out of luck. So making that mistake can really cost you. And those are the three biggest issues that I see.
Yeah, for sure. I'm glad we talked about the class thing too, because that was something I literally came to you knowing nothing about trademarks. So I was like, I'm not going to learn this, so I better just hire someone. But yeah, because that was an interesting thing to talk about too for the authentic AI one, really talking about what do you want to do with authentic AI. And so we talked about the podcast, we talked about courses and stuff like that. And how those classes looked and what the little nuances for each of the classes and stuff. And so that was very helpful because we went deep into that and how, a membership is different than the class, whatever, the digital course class, or what else were we talking about? Oh, digital products or templates or assets are a different class too. And so, yeah, there's all these little definitions that you might not even realize are a different class than what you're applying for sure. So
right. And if you are applying yourself and you apply in one of those classes, but you actually need to apply in all three and you leave that off of your application, you can't go and add it on to your current application. You have to then submit an entirely new application. And when you do that, again, you're starting over from the beginning. If the classes are different, then those could be considered unrelated enough to your current application that somebody else could come along in there and swoop in and get it for a different class. So it's so important to have an accurate and complete class description before ever applying for the trademark, to do that search, and then, of course, to have a comprehensive application.
Yeah, definitely. And exactly, it's it coming back to why you're applying for a trademark in the first place. It's okay, well, if you want to add on digital products or something after, and then you go back to apply for that trademark, but there's someone else over here that's already kind of applied for that class or whatever, it can get very confusing.
Right.
So, yeah.
I like to use the example of Dove soap and Dove chocolate. Both of those Dove trademarks are registered trademarks. Both of them are obviously one's for soap and one's for chocolate, so they can coexist without issue because the thought process is that consumers are not going to try to buy chocolate, reach for chocolate in the chocolate aisle and accidentally take home soap. So there is no likelihood of confusion there. But if Dove chocolate ever wanted to expand into, body care products, they cannot do that because of the Dove soap registration. So they missed their window to apply for those types of trademarks if that was something they wanted to do. So you have to really consider how your brand will evolve over time, what services you want to offer in the future. If you want to offer goods or sell goods or digital products, you have to really be thinking about that, again, before ever submitting that application.
Yeah, for sure. And that is so funny. I interviewed this woman from Australia who started a coffee company it's like a low caffeine coffee company for like mothers and stuff like that. And we were recently talking about how she's starting to incorporate a skincare line that's like coffee infused skincare. And I'm like, that's such a good idea. I love making homemade coffee face masks and stuff. But
yes.
But, like I'm thinking about this right now, like you could possibly, there could be that crossover, which is crazy to think about.
And they're totally different classes. So you have to redo that. Yeah. Redo that analysis. Think about what's out there that could be confusingly similar. But yeah, even if that's not really the natural progression of a coffee company, right? Most coffee companies aren't going to go in that direction. So you have to really think about all these moving parts.
Yeah, for sure. So you already kind of mentioned this, but if your trademark does happen to get denied, I mean, it sounds like you can kind of go back and forth like one or maybe a few times and try to fix it. But then if it is denied, it's not like the end of the world. You can reapply if needed and stuff like that, right?
Yes. Depending on why the application was denied, then yes, you can reapply. If the application was denied because there's someone else out there that has a confusingly similar mark to yours, then reapplying will not fix that issue. And then you're looking at rebranding. It depends on why the application was denied. But yeah, there are generally ways you can overcome those office actions. And I see a lot of people apply for the trademark themselves, get an office action, not understand how to respond to the office action, and then lose their trademark because they just didn't respond. It will just be denied if you don't respond. And if you get an office action, you should hire somebody to respond to that because you're so close potentially, again, unless someone else is out there with a confusingly similar mark. And even then you can still make the argument depending on what the marks are, what your goods and services are, but you shouldn't just give up and let your application die when you're already that far.
Oh, okay. So I kind of want to take it back to the basics real quick because I totally forgot to ask you this at the beginning. But can we talk about like what a mark is? I think this is something I asked you to clarify during our discovery call.
Yeah. So when I say mark, when I'm referring to your trademark, it's just a habit. And in the profession, trademarks are just referred to as marks. If it's your business name, say you're brainstorming business names and I'm like, what's your mark? Then I want to know what business name you landed on or what that trademark is. So it's just mark and trademark are just used interchangeably. I don't know if it was originally shortened, maybe because there are service marks versus trademarks. It's just, again, very similar and the same thing essentially. So mark is just the shorthand version of it. And then something else is when I am writing your trademark out, it's common practice to write that trademark in all caps, like when I am just emailing you. And so when I'm talking to a lot of my clients, I'm like, no, this is not how I'm applying for the trademark in all caps unless you're using it in that way. But that's just how I use it in emails and in written correspondence. And you'll see that from the USPTO. And they'll use mark as well. So yeah, those two things confuse a lot of my clients because they're like, what are you talking about? And why is it all caps?
Well, and like, what are some of the things that we need to think about when it comes to choosing that specific mark? You know what I mean? Because I think that's something we had discussed too is like authentic AI or authentic AI for entrepreneurs and like how long can it be or what should it be? Like, what are some of those nuances?
Yes. So when you're applying for a trademark, you want to apply for the mark exactly as you're going to use it. And again, it's a very long process. So if at the very beginning you apply for the trademark, but you decide, okay, I want to add 4 entrepreneurs on the end of my mark, or I'm going to use it this way, then that could impact your trademark applications. You have to consider, one, if that will impact your trademark application. And again, before ever applying, you want to consider exactly how you're going to use this trademark. Where you have this descriptive language that you're adding on to the end of your trademark, you can either omit it entirely. And a lot of my clients will do that just to not have, this long trademark. They want something that's short and simple. And then they can add that language in the future, but then open themselves up to the possibility of having authentic AI for lawyers or authentic AI for entrepreneurs, and being able to kind of add on and expand your services as your business grows and not be tied down to this for entrepreneurs specifically language. Consider exactly how you want to use it and will use it. And again, how it's going to evolve and how you may want to change and not want to be tied down to a very, very specific word or description, unless that is your ultimate goal, to be tied to that description. Where you have this unique trademark, but then this descriptive language, also you have to disclaim that language is what it's called, meaning that anybody else can say for entrepreneurs in their trademark application, which is not uncommon. It doesn't impact you in any way negatively, but it's just something to consider that language is going to be disclaimed. So you can't really claim it as something you own. And again, with that, you might not care to own it. So a lot of considerations when you're actually trying to narrow down exactly how you want that trademark to look and be used.
Yeah. And I was going to say too, something that popped up is, so when you're applying for trademarks and whatnot, and you're choosing different classes and how you're going to use it, there was something that we talked about where, do you need to be currently using this trademark? And maybe the coffee / skincare example too. It's like, okay, well, maybe she would have applied for the coffee trademark back in the day, but then she wasn't currently doing the skincare one. Like, what does that look like?
Yeah. So if like right when you start your business, okay, we're doing coffee and skincare, then you can apply for both at the same time. If you're not yet using the trademarks, you have to apply on what's called an intent to use basis. And that is you saying, okay, I'm not using this trademark yet, but I plan to at some point in the future. And we see this happen with a lot of celebrities who want to get their foot in the door, secure this mark in a way. The trademark won't register. You have to show that you're using the trademark for it to ever register. But having that intent to use application in just secures your spot in line to that ownership. So you can apply as soon as you have this idea and like, these are the things I want to do. You submit the application on that intent to use basis and then build your brand. In the alternative, if you are already using the trademark and you're like, okay, I have been using this for a few years now. I love it. I want to protect it, but I don't have a trademark. You can still apply for a trademark. That is not at all uncommon either. That is on what's called a 1A or a use basis. So you can apply in either circumstance and where you are. So say you have coffee and you've applied for this trademark, it's registered. A few years later, you do skincare, you would submit a second application for the exact same trademark in that different class. And we see that happen a lot, again, with these larger companies. Like Starbucks is a great example because their initial applications were for coffee. So they have all of these coffee registrations, but then they expanded into, their mugs, and then they expanded into energy drinks. So if you search tests for Starbucks and you see all the Starbucks marks, you'll see exactly how, okay, they're having new products, new services, and they're just applying for that Starbucks trademark over and over again. So not at all uncommon, but you have to do that search prior to ever filing just to make sure nothing else is out there when you are expanding.
Do you ever see people trying to take advantage of companies where it's like, maybe Starbucks like applied for the coffee one and then they kind of got big and someone is like, oh, well, I'm going to apply for a Starbucks trademark in a different area because, I see them expanding areas. Like, do you ever see cases like that?
Yeah. So that actually happened with Facebook when they announced Meta. We saw hundreds of Meta applications and people were thinking like, okay, I'm going to sell this to Facebook and they're going to pay me for this. That is fraudulent, and committing fraud on the federal government is something that I would never advise. Your trademark will never register if you're not using it in connection with whatever you're applying for. So your mark will never mature into registration that, you'll even be able to sell or do anything with. So it's really pointless. You're wasting your money. And again, it's fraud. And with it being fraud, your application can be canceled and you can get in trouble. So you don't want to do that. But it does happen. The same thing happens with domain names and in connection with trademarks. So if you apply for a trademark, there are people who sit and watch those new applications come in because it's all public information. They'll see, okay, I see you applied for this trademark. I'm going to buy this domain name. They'll buy tons of domain names and then try to sell them back to you for thousands of dollars more. And that's fraudulent, but it happens every single day. And for a lot of business owners, they're like, I don't have the money to fight this or to pay them for the domain. So I'm just out of luck. So yeah, it happens a lot. People do try to make a buck off of trademark applications or the domain names with the trademark applications, but it is fraudulent.
So don't do it, guys.
Don't do it.
Just kidding.
Don't do
doubt
it.
that anyone listening to this podcast would be thinking that. But I'm glad that we brought it up for the domain names as well, because that's something that you had warned me about as well, is go on a domain name search, get the domain names that you want to use, like prior to us filing, because that can happen. So that's definitely something to think about. So I know this might be difficult, but to just try to break it down to like kind of an easy step-by-step process, like of people who might be interested in trademarking their name and stuff. And then, of course, I want to chat about how you actually work with your clients to get that process done. But for someone who's like thinking about doing this, like maybe what are some just like those first starting steps that they should do?
Yeah. So first starting steps are to narrow down exactly what your trademark is, exactly what you want to protect, and consider if it's, protectable. So think about your trademark, think about the classes that you're using that trademark in connection with, and that is the goods or services you're providing under that trademark. You want to make sure you have those narrowed down to an extent. With all of my clients, I am working on that class description. So just on the business owner end of things, you don't need to necessarily worry about what class number, but you should have an idea, of course, of what goods or services you're planning to offer. So those two things are going to be huge. I always recommend you also test that USPTO database, because even though it's not comprehensive, if you search that database and you get a kickback right away and you see, okay, this person does have this identical trademark, they're offering identical services, then you're going to immediately know I should not move forward with this. So you can do that yourself just as a quick preliminary search. And then also search on Google. Again, those two searches are not at all comprehensive. That's not going to be near enough to file the application, but it's such a great place to start, because I will have people who come to me and say, okay, this is my trademark. This is how I want to apply for it. And I see immediately that there's someone on Google who comes up and they have the registered trademark symbol next to their name. They already own it in connection with the same thing. So just having done that little bit of research and narrowing down your trademark and your goods is going to make a world of difference when it comes time to hire someone, or even, to apply for the trademark yourself.
Yeah. Okay, cool. And then let's just talk a little bit about you and kind of the work you do and what you offer your clients to make the journey way easier. Cause like, that's what I ended up doing, guys.
Yes. And that's my goal. I want to make it as easy and as hands-off for my clients as possible. And so what I do is when I onboard my clients, what we do is we immediately start with that clearance search. So I do that comprehensive search. I outline any issues with your potential trademark. We discuss the exact class description. So we narrow that down. And again, this is hands-off for you in the sense that you're not having to draft this and figure out what the legal description is. I'm drafting it to you, sending it to you. You're reviewing everything on the front end of things. If there are no issues with that clearance search, it's green light, looks good to apply, then I prepare and file the application. So all of the most important work is done before ever filing the application. I prepare and file the application, and then it takes about 10 months for that application to be assigned to an examining attorney at the USPTO. And at that time, we see some movement, and I update you on what's going on with your trademarks. I will have notifications from the USPTO. So I update you as things move along. There are a lot of smaller phases throughout the application process that I'm then explaining to you, like this is what to do next. Nothing's required on your end, for example. And I just keep you posted as things move along. And then the mark registers, and that entire process is, again, about a 12 to 18 month process. So when I say it in 30 seconds, it seems so cut and dry, but it is a very long process. And that is assuming no issues. So if the USPTO has any issues, they will either call me directly as the attorney of record or issue that office action. And when that happens, I handle that for my clients as well. I update you. I say, this is the office action. Here's what it means. Here's what we'll do. And then keep progressing. So yeah, that's the overview of working with me for the trademark application process. And now when your trademark registers, the USPTO doesn't automatically send a trademark registration certificate either. They're trying to make things more electronic. So I, of course, send all of that to my clients. And after I filed the application, even though that entire process is done, I am still listed as the attorney of record on your application, which unless for some reason my clients can go in and change that and take me off if they wanted somebody else or didn't want me at all, that is something they can do. But I will continue to get notifications for your trademark registration after it registers, which I can then update you about. So that's just another benefit to having me, even when the application and registration process is over.
Yeah, that is so nice as well. I'm horrible at answering phone calls and emails, so it's so nice to have that just for someone like me. But also, I guess, what's your opinion on, like, if someone were to work with you or another attorney that's very trademark focused and stuff, and like you have someone kind of look at your trademark and say, yes, this is good to go. Like, do you find that it's normally successful, especially if you have that pair of eyes on it that knows what's going on, right?
Yeah, that's a good question. And so the way I do my analysis is I do that clearance search and I say, okay, this is high risk, this is moderate risk, or this is low risk. Most of the time, I rarely see applications that are low risk unless they're made up or they are at the very forefront of this industry. They are at the very first one to apply. You're really not going to see that low risk. Most applications have some risk involved. And when I say a mark is high risk, then yes, that is something like if I'm saying it's high risk and it's not going to get approved, I know it's not going to get approved. I have some clients who are like, I want to fight for it anyway. Like I will pay for it. We're going to fight for it. And we do that. And that can be, again, that year-long process where you're fighting for this trademark. But if you want to try, it's possible. But if I say it's high risk, then it most likely will be denied. If I say it's low risk and I don't see anything else out there, the USPTO is notoriously unpredictable. And so there is something that it's possible that something could come up. So if I say it's low risk, then I'm generally very confident in that. Like I will never say low risk unless I'm very confident in that. But I always make the disclaimer that something could come up because, again, the USPTO is so unpredictable and it's been getting worse and worse. So something that even with the existing case law may not be similar at all, they could still say it's similar and then we have to push back on that. So I don't know if that answers your question, but
yeah, totally. No, it does. And it's just kind of good to like know about and ask these questions and stuff because and I'm laughing too because the government sounds like the Instagram algorithm to me right now.
Yeah, very much so.
But yeah, I know it's like, rolling your eyes at it. Don't listen, government.
Right.
Okay, just like a little bit kind of follow up. So once you do get a trademark, I guess we haven't even talked about like the cost of getting a trademark. Like, what does that look like? And then what's kind of the maintenance for after you trademark your business name or whatever?
Yeah. So if you work with an attorney, your price range is generally going to be anywhere between $2,000 and $7,000. Most trademark attorneys are going to work on a flat rate. I've noticed that is just more and more common. And I have a number of trademark attorney friends, of course, and I know that their ranges are just right in there. I don't really see anything over that $7,000 unless you have a ton of classes you're adding on, because each class has a filing fee. So if you have a ton of classes, then you are going to have additional expenses that can add up. So that initial expense is going to be a few $1,000s. If you go with a service like Trademark Engine or LegalZoom, that is going to feel cheap to you because it's probably going to be less than $1,000. But I have so many clients who come to me to fix those applications. So if you were going to go that route, it's better to just do it yourself and only pay the filing fee costs, which are still between $250 and $350 per class. So you're having at least a few $100s, even if you don't hire an attorney. But if you're hiring an attorney, it's going to be a few $1,000s for that initial investment. Once your trademark registers, you will not have any maintenance fees until between the 5th and the 6th year following registrations. You'll have that renewal fee, and then you get another 10 years. So you will have renewals. There are scam companies that will say, hey, this money's due, and it'll look convincing and you should not pay those. If you continue to renew after that first 5th and 6th year period, every 10 years after that, your mark can stay alive forever. And then again, at that point, you can sell it to someone down the line or license it out or whatever the case may be. But after the registration, your upkeep fees are very minimal.
Okay. Good to know. This was all such great information. I'm like, we already had this discussion. I'm still like, yes, okay. I'm so interested. And I know everyone is going to find this so helpful. So thank you so much for coming on the show. Can you please share how everyone can connect with you and find out more about you? Because I know they'll want to do that for sure.
Yes, I am on Instagram at Denver Trademark Law, and I try to break everything down into more bite-sized pieces on Instagram. So I'm not just drowning you in all of this information, but I am on Instagram. My website is also denvertrademarklaw.com.
Yes. And you are based in Denver, which is awesome, Colorado girl, but you do work with people all around the country, right?
Yes. So trademarks are governed by federal law as opposed to state law. So all of my trademark clients can be located anywhere in the US or even outside of the US. So anywhere in the US for trademarks. If you need custom contracts, though, because I'm licensed in Colorado, I only work with Colorado clients for custom contracts. But I also have the C-Suite, which is a contract template shop, which is designed for anybody in the US to use. So,
oh, hello. I didn't know about the C-Suites. I'm going to have to go check that out.
Yes.
So what kind of contracts do you have in the C-Suite?
I have a range of different contracts. I have the privacy policies for your website, terms and conditions for your website, digital product terms as well, and then other contracts like your employment offer letter, your independent contractor agreement. So a range of different contracts that I found were most requested by my clients. And I wanted to give people a source that was a place where they knew, okay, this is going to be attorney drafted. This is my trademark attorney. I know what to expect from her. I can get this and use this in my state. So
okay,
a range of those contracts.
Awesome. I kind of would love to ask you a little bit about AI technology.
Yes.
And if you have any kind of thoughts about all of this new stuff that is coming in, and it might be kind of a big question. Feel free. You don't have to be an expert and feel free to, only share what your thoughts are and stuff. But how are you feeling about AI technology kind of starting to be integrated into the mainstream marketing world and our lives and our businesses and all that stuff?
Yeah, I think it's awesome. From a legal standpoint, I see a lot of fear in the profession. Like, okay, we're getting replaced, but I just know that won't be the case in my profession or in so many other professions because people love that personal interaction, that relationship that, you don't want to call and get a robot and be pressing buttons all day. Even if the robot is really good at what it does, you want to talk to somebody. So I think it's great. I don't think that it's really going to be a negative thing in any industry. In the legal world specifically, I actually did something on Instagram recently where I reviewed an AI drafted contract. And the contract was okay. It really was okay. It wasn't amazing. There were terms that were missing from it that if you did get into a dispute down the line, you would have issues fighting over these terms that were not included. So that's something to consider, that it's just not comprehensive, but it's such a great resource for people who don't have access to whatever it is they need. It's going to be, in my opinion, great for underserved communities. AI is amazing if you need to generate content or you're just having one of those days where the gears in your brain are just not moving and you need some help. It's great for that. It will just spit out idea after idea. It's fun, in my opinion. So yeah, I'm very much interested to see how it evolves, especially as it becomes more accurate and maybe one day I will say, write me a contract. I did an independent contractor agreement. So I said, write me an independent contractor agreement. I did it twice. Both times it was different. Both times it was missing terms. But as time goes on, I wonder if there's, one day it's going to be like this amazing contract, which would be really cool. So I'm interested to see what happens with AI.
Oh, yes, totally. I'm so glad I was able to ask that because, yeah, I know it's so interesting to be and to hear it about like people's thoughts who are in different industries and what they're seeing. And I know it is so interesting. And like, I keep saying this because it kind of, I feel like especially for people who are just starting out, just starting to dip their toes into playing with ChatGPT and other AI stuff, that like they don't realize that it's not a know-all being, right? Like, it's not always correct. It's not even always factual, and exactly, it's so interesting that like you put the contract in 2 times and it came back with different things both times. I have been finding that myself too. It's like, it's not like you just ask it a question, it has like a canned response.
Right.
It's generating stuff, right? So it's always going to come back different. And truly, it is always good to have those professional eyes on anything that AI creates so that you know that it is actually correct and that it's just not spewing BS at you.
Right. Yeah. And something else to consider, I was just reading an article earlier about how this artist tried to apply to protect his art with copyright protection. And the art was something that he had generated with AI. And then he took that generated work and edited it in Photoshop. And the US Copyright Office said, no, this isn't your work. Like you just taken somebody else's work. It's not yours. And so we're seeing a lot of that in the art industry, just a lot of copyright issues with AI. So that's been interesting to see. And then also with content where, maybe you need a blog post or an Instagram caption or whatever it is, that content is not your content. That has been generated by somebody. Somebody authored that, whether it is the AI program, somebody owns that. That is not you. And that is something you have to consider. You can't just, be publishing an AI book, for example, because you will get in trouble. And it's just, very interesting to see how people are challenging it. It's such a new area of the law that when we're seeing these cases, it's like artists are suing these platforms, the AI platforms, because they are taking their artwork or things like that. And it's just so new and uncharted territory that it's interesting to see evolve. And you can't rely on it to do your work for you with whether it's written text or generating these images or whatever it is. It is such a great tool, but if you're relying on it in any of these other ways, you could get into a lot of trouble.
Yeah, I know. Oh man, I am so just intrigued by how this is evolving. And it's just good to be aware and also realize that it is evolving. And so be on your toes when it comes to this stuff and whatnot. But yeah, I actually, and I'm going to be interviewing a different lawyer for the AI podcast that I have now next week. And if you're ever interested in being on Authentic AI, please let me know. I'm totally down for it. And she was talking about how it's good to have, if you do, for example, create a course or something and you have AI help you with that, ChatGPT or whatever it is, it's good to have, she wrote up contracts for saying or a disclaimer, I guess, that disclaimer, this was created with the help of AI and what is your original thought at this point? And that's hilarious about the book writing too, because I've heard so many people being like, oh, I've written romance novels with ChatGPT and put them on Amazon. And it's they are getting in trouble for that.
Right.
Oh,
it's so interesting. Yeah, to see. I'm going to have to listen to that episode because it's very interesting. And having that disclaimer, if you're using AI to create anything in your business is so, so important too. So it's very interesting.
Yes, very good to hear about. Okay, well, thank you so much for this conversation. I have truly enjoyed it so much, and I can't wait to share it with my people.
Yes, thank you for having me. I had so much fun chatting with you, and I'm looking forward to hearing your other episodes.
How great was Taylor, you guys? I was just so grateful to her for coming on the show and just sharing all the ins and outs of trademark law with us for this podcast, because it's definitely something we all need to be considering as we are moving forward and continuing to grow our businesses, right? So don't forget to connect with Taylor and myself on Instagram. Both are linked in the show notes below. We would love to hear from you. Let us know that you came from the podcast, and we'll definitely hit you up and spread some love in the DMs over there. And I just really hope that you enjoyed this conversation, and I can't wait to catch you next time.
Thanks so much for listening, my friend. For show notes and a whole lot of other awesome freebies, visit feelgoodsocial.com. Simply go to feelgoodsocial.com for all the goods.